Real people, real properties, real insights.
Welcome to the Real Estate Diaries.
7%. That is the number that jumped out at me immediately when I cracked open this week's research stack. According to Statistics Canada, 7% of Canadians have been evicted at some point in their lives.
Yeah.
And that's not just, I decided to move, that is, you have to leave.
It's a sobering statistic, and you have to contextualize that with the stress factor. We know that moving is consistently ranked as one of the most stressful life events a person can go through.
Right up there with divorce or losing your job.
Exactly. So when you take that inherent stress and add the element of force, usually in a very tight timeline, it just takes that psychological toll to a completely different level.
Absolutely. And that's exactly why we are tackling this today. We aren't just looking at lease agreements, we're looking at housing security.
Right.
We're deep diving into rights, rents, and this rising kind of terrifying phenomenon of renovictions. But here's the twist. We aren't just looking at one set of rules. We're doing a comparative deep dive between two Canadian heavyweights, Ontario and Alberta, which is a fascinating comparison because as we went through these government handbooks and legal guides, it became so clear that depending on which side of that provincial border you live on, your reality as a renter
Or a landlord.
or a landlord is wildly different. The entire philosophy of the law changes.
It really is a tale of two provinces. So the mission for this deep dive is to unpack those differences. We're going to look at the Residential Tenancies Act, the RTA in both places. We're hitting the specific pain points, the rules of entry, how evictions actually work, and the nuances of renovictions.
So let's start right at the front door, the privacy factor. Because this is often the first place where that relationship between a landlord and a tenant starts to fray a little bit.
Knock, knock, who's there?
Yeah.
Hopefully not my landlord, unannounced. Now, despite the massive differences we're going to see later, both Ontario and Alberta actually seem to agree on the golden rule of entry.
They do. In both provinces, the baseline is, well, it's respect for privacy. A landlord cannot just waltz in to check on things. They need to provide written notice at least 24 hours in advance, and there are strict time limits. Entry can generally only happen between 8 a.m. and 8 p.m.
And they need a valid reason, right? I think that's a common misconception. Some landlords think it's my property. If I give 24 hours notice, I can come in whenever.
Definitely not. The notice isn't a blank check. Valid reasons are really specific. Inspections, repairs, pest control, or showing the unit to, say, prospective buyers.
You can't just enter to snoop.
Exactly. Although you did notice a specific little carve-out in the Ontario source, right? About cleaning.
Yeah, the housekeeping clause.
Right. So if the lease explicitly says the landlord will clean the unit, like in a service department, they can enter to do that without the 24-hour notice as long as it's within the hours in the agreement. But that's the exception.
It's not the rule. Now, here's where it got really interesting to me. I was reading about a court case in Ontario, Rona v. Toronto Community Housing Corporation.
Yes.
And this case really highlights that just following the letter of the law isn't always enough.
This is such a crucial nuance. In that case, the landlord did give the 24-hour notice. They checked that box. But they said they would enter for inspection sometime between 8 a.m. and 5 p.m.
A 9-hour window. Stay home all day, we might show up.
Exactly. And the divisional court ruled that was unreasonable. They said that while the landlord has a right to enter, the tenant has a right to the reasonable enjoyment of their home.
So you can't hold their whole day hostage.
You can't. The entry window has to be specific and reasonable. It puts that human element back into the legal text.
I love that. But let's get back to the no-notice exceptions. Because life happens. If a pipe bursts, nobody's waiting 24 hours.
Correct. That falls under the emergency exception. Fire, flood, immediate danger. In those cases, the notice rule goes out the window in both provinces.
And if the tenant is home and just says, sure, come on in.
That's consent. That's fine too.
Okay, so that's the baseline. But then I looked at the Alberta handbook and I saw an exception that it made me pause. It felt very different.
You're likely looking at the abandonment clause.
Yes. In Alberta, if the landlord has reasonable grounds to believe the tenant has abandoned the premises, they can enter without notice.
And that is a distinct difference in philosophy. In Ontario, determining abandonment is a process. Generally, a landlord has to apply to the Landlord and Tenant Board, the LTB, to get a determination.
It's about due process.
It is. Whereas Alberta seems to say, if it looks like they left, go secure your property. It empowers the landlord to make that judgment call much faster.
Right. And that theme speed in Alberta versus process in Ontario is going to come up again and again.
It really is.
Which brings us to the heavy stuff, evictions. Specifically, when things go wrong with conduct or money.
This is where the two systems really, really diverge. Let's talk about non-payment of rent. It is unfortunately the most common dispute.
So in Ontario, I see references to the N4 form.
Right. So in Ontario, if a tenant doesn't pay, the landlord serves an N4 notice. But that notice basically just tells the tenant to pay up or move out if they don't do either.
The landlord is stuck.
They're stuck. They can't just kick them out. They have to file an application with the LTB and wait for a hearing.
And we know from the sources that those hearings can take months.
Sometimes 8 to 12 months, depending on the backlog. It's a judicial process. The tenant stays in the unit while the landlord waits.
Now, contrast that with Alberta.
Alberta is brisker.
That's a polite way to put it.
In Alberta, for a substantial breach, which includes non-payment, the landlord gives a 14-day notice to terminate.
Just 2 weeks.
2 weeks. However, there's a very important safety valve. If the tenant pays all the rent owing within those 14 days, the notice is void. It disappears.
So it's a strict deadline. Fix this in 2 weeks or you're out.
Exactly. It's a cure or quit system. But there's another tool in Alberta that I think will shock some of our listeners.
The term distress or distraint. I honestly thought it was a typo. It sounds like something from a Dickens novel.
It does sound archaic, doesn't it? But it is a very real, very powerful tool in Alberta. Distress allows a landlord to hire a civil enforcement agency to seize the tenant's property to cover unpaid rent.
Wait, let's unpack that. They can actually take your stuff, your TV, without going to a judge first.
That's the key without a court order. As long as the tenancy is still active, the landlord can have a civil enforcement agency seize goods found in the rental unit.
That is wild.
They hold the goods, and eventually they can be sold to pay off the rent debt. Now, there are rules. They can't take necessities like clothing or medical aids, but yes, your electronics, your furniture, they're fair game.
I cannot imagine that flying in Ontario.
Oh, it wouldn't. Ontario strictly prohibits that. But in Alberta, it's a standard tool. It treats the lease almost like a secured debt, where your personal property is the collateral.
Wow.
This episode of the Real Estate Diaries is sponsored by PropCare. If you're a builder, landlord, or property manager, you know the reality. Most of your day isn't spent growing your business. It's spent coordinating it. After-hours calls from tenants, chasing trades for scheduling, endless paperwork and follow-ups. PropCare is a voice-first AI platform that handles all of that for you. It answers every call 24/7 under your brand, coordinates trades, tracks expenses, and documents everything automatically. Built in Canada for Canadian property operators who want to run their business without it running their life, because every call you don't have to take is time you get back with the people who matter most. For more information, visit propcare.ca, and now back to the Real Estate Diaries.
Okay, let's talk about behavior, because it's not always about money.
Right. Sometimes it's about safety. And again, the timelines tell the whole story. In Alberta, if a tenant physically assaults a landlord or another tenant, the landlord can serve a 24-hour notice to terminate.
1 day. Get out.
Immediate removal. The priority is safety. In Ontario, you have eviction for illegal acts or impairing safety, but you still generally have to go through the LTB hearing process to get the eviction order enforced.
So even if someone is threatening other tenants, the landlord in Ontario has to file paperwork and wait.
They can request an expedited hearing, sure, but it is not the immediate 24 hours and you're gone mechanism that Alberta has. It feels like Ontario prioritizes security of tenure, while Alberta prioritizes property rights and immediate contract enforcement.
That is a very fair synthesis, and nowhere is that tension more visible than in our next topic.
Renovictions.
Renoviction, the portmanteau of renovation and eviction.
Right. I think most people know the concept. The landlord kicks you out to fix up the place. But the suspicion is that the renovation is just an excuse. The real goal is to break rent control. That is the core of the issue. The StatsCan data we looked at really connects the dots here. They found that recent renters pay significantly more than existing renters. In Toronto, the gap is about $510 a month.
That is massive. That's over $6,000 a year. So if a landlord has a long-term tenant paying $1,500, and the market rate is 2,000.
They have a huge financial incentive to get that person out.
Yeah.
The renovation is the mechanism to empty the unit and reset the rent.
So let's look at how the provinces handle this.
Mhm.
Ontario uses Form N13. They have to give 120 days notice.
4 months. And the landlord also has to provide compensation, usually 1 to 3 months rent. But the golden ticket for the tenant in Ontario is the right of first refusal.
Right, I read this. The tenant has the right to move back in once the work is done.
And critically, at the same rent they were paying before.
So the landlord spends all this money renovating, puts in new floors, but they can't raise the rent.
Not beyond the guideline, no. This rule is designed specifically to stop bad faith evictions. If the landlord knows the tenant is coming back at the old low rate, there's no financial gain.
Ideally, yes.
Yeah.
But the sources mention that cities like Hamilton and Toronto are stepping in with their own bylaws. Why do they need to if the provincial law is so strong?
Because enforcement is the problem. A tenant might have the legal right to return, but if the landlord just ghosts them or rents it to someone else, the tenant's only recourse is a long battle at the LTB. These new municipal bylaws require landlords to actually get a renovation license before issuing the notice.
I see. It puts a barrier up front. Show us the permits. Prevention instead of punishment.
Exactly. Now look at Alberta. Their approach blew my mind.
The 365-day rule.
It is unique. In Alberta, if a landlord wants to evict for major renovations, they must give 365 days notice.
A full year.
A full year. And during that notice period, they cannot increase the rent.
Wow. So on one hand, that gives the tenant a huge amount of time. But on the other hand, unlike Ontario, there's no right of first refusal, is there?
Generally, no. The 365-day notice terminates the tenancy. Once you're out, you're out. So Alberta trades the right to return for a very long transition period.
It's a fascinating trade-off. Ontario says you can come back, but the system makes it hard to enforce. Alberta says you can't come back, but we'll give you a year to figure it out.
It creates a very different experience for the renter.
And this leads us to the other big reason people get evicted: landlord's own use. StatScan says this is actually the leading cause of eviction.
37% of cases, yeah. The landlord is selling the property or moving in themselves.
Which brings us to a term that wasn't in the government handbooks, but was all over the legal guides. Cash for keys?
Yes, this is the shadow market of eviction.
I want to make sure the listener understands this. Why does this exist? If a landlord have a legal right to move in, why are they paying tenants thousands of dollars to leave?
It goes back to that backlog. In Ontario, if a tenant decides to challenge an eviction, which is their right, it can take 8 to 12 months to get a hearing.
So if I'm selling my condo and the buyer wants to move in next month,
You are stuck. The sale will fall through. So the landlord does the math. It'll cost me $50,000 if the sale falls through. I'll pay the tenant $10,000 to leave voluntarily next week.
it's basically buying your way out of the line at the landlord and tenant board.
That is a cynical but accurate way to view it. These agreements are legal as long as they're voluntary, but they are a symptom of a system where the formal legal pathways are just too slow.
We've covered a lot of heavy stuff, but I want to touch on some specific protections that actually gave me a bit of hope, specifically regarding domestic violence.
This is an area where legislation has really evolved. The Alberta Safer Spaces Certificate is a standout piece of policy.
Tell us how that works.
If a tenant is in a domestic violence situation, they can get a certificate from a designated authority like a police officer or a social worker. With that certificate, they can terminate their tenancy with just 28 days notice.
And they don't have to pay a penalty for breaking the lease.
No financial penalty. The priority is allowing the victim to flee safely without being tethered by a contract. It's a crucial safety valve.
That is incredibly important. The last thing you need when fleeing violence is a landlord chasing you for rent.
Speaking of money,
I knew you were going to pivot there. Let's talk fees and deposits. I feel like this is where tenants get nickel and dimed.
it's the Wild West of fees sometimes. Both provinces agree on the security deposit. It cannot be more than 1 month's rent. But here's something I want the listeners to hear clearly. Both provinces require landlords to pay interest on these deposits.
I bet a lot of listeners just perked up. Wait, I get interest?
You are supposed to. It's your money held in trust. Now, in practice, the interest rates are often set very low, but the principle stands.
But the difference comes in the other fees.
Huge difference. Alberta is much more permissive. If you agree to a re-rental fee or a non-refundable pet fee in your lease, that's generally binding.
And Ontario?
Ontario is much stricter. The law prohibits most non-refundable fees. You can't charge a key deposit that's higher than the actual cost of the key. If it's not explicitly allowed in the Act, it's generally illegal, even if it's in the lease.
So if you sign a lease in Ontario that says non-refundable $500 pet fee, that clause is likely void.
Almost certainly void. The LTB would likely throw that out immediately. You cannot sign away your rights under the RTA.
That's a key takeaway. Just because it's in ink doesn't mean it's legal.
Precisely.
So let's zoom out. If we had to synthesize the difference between being a renter in Toronto versus Calgary, how would you characterize it?
It comes down to a philosophical difference in who bears the risk. Ontario's system is built on security of tenure. It is very hard to lose your home, but the cost of that security is a rigid, slow, bureaucratic system.
Which leads to things like cash for keys.
Yeah.
And Alberta.
Alberta is built on market flexibility. It's easier to evict for non-payment. Landlords have powerful remedies like distress. But they also balance that with clear, long notice periods for major changes like renovations. It's a faster system and maybe a more precarious one for a tenant.
And we are seeing the landscape shift.
Yeah.
That final point about the municipal bylaws, Hamilton, Toronto, creating their own rules for renovations, that feels significant.
It is very significant. It suggests that municipalities are feeling the heat of the housing crisis in a way that the provincial legislation isn't addressing fast enough.
They're stepping in to protect their affordable housing stock.
Exactly, because once those units are renovicted, that affordable rent is gone forever.
It raises a big question for you, the listener. As we see more of these city-specific bylaws popping up, are we moving toward a patchwork of tenant rights where your protection depends not just on your province, but on your zip code?
That is exactly the direction we seem to be heading. It's becoming a hyper-local issue.
A huge thank you to everyone listening to this deep dive. Whether you're signing a lease in Edmonton or Ottawa, do yourself a favor. Pull out that contract, check your local rules, and know your rights. Don't assume the law is what you think it is. We'll catch you on the next one.
Thanks for listening to today's episode of the Real Estate Diaries, sponsored by PropCare. PropCare is the voice-first property operations platform that gives builders, landlords, and property managers their lives back. By automating tenant communication, trade coordination, and maintenance workflows, PropCare handles the operational chaos so you can focus on what you do best, growing your portfolio and protecting your reputation. To learn how property operators across Canada are scaling without the stress, visit propcare.ca. We'll see you next time on the Real Estate Diaries.